Hello viewers, here we are today to discuss another topic in the subject of Economics and Law Part 1. I am Dr. Ankit Shrivastava, Assistant Professor of Law at Rajiv Gandhi National University of Law, Patiala. The lecture of our discussion today is Economic Analysis of Consumer Rights and Competition Law. The corporate sector has boomed as a result of the Industrial Revolution in global trade and commerce, which has led to a variety of consumer goods to meet consumer needs and a wide range of services like banking, insurance, transportation, electricity, housing, entertainment, and economics available to consumers. The rise of a well-organized industry of manufacturers and traders with superior market knowledge has impacted the connection between traders and consumers, essentially rendering the idea of consumer sovereignty meaningless. Advertisements in television, newspapers, and magazines influence consumer demand for products and services despite potential manufacturing flaws, imperfections, shortfalls in quality, quantity, purity, or deficiencies in services provided. Because multiple companies are producing the same product, consumers must consider their options before choosing the best one. It is crucial to check the market for an overabundance of contaminated and subpar goods in order to safeguard the public's well-being. Despite numerous laws stipulating strong penalties for contaminated and subpar goods, as well as regulations protecting consumers, there has been very little progress in the area of consumer protection. The Prevention of Food Adulteration Act of 1954 and the Monopolies and Restrictive Trade Practices Act of 1969 helped consumers, but their interests still need safeguarding, protection from exploitation, and defense against subpar and adulterated goods and services. In the history of consumerism, the year 1986 saw the promulgation of the Consumer Protection Act. It was the first law of its sort to be passed in India with the express purpose of easing the suffering of customers who are the targets of deceptive business practices and inadequate services. On December 5, 1986, the Consumer Protection Bill 1986 was introduced in the Lok Sabha with the goal of improving consumer interest protection. It was observed by Justice Y.V. Chandrachud that the interest of the consumer has to be kept in the forefront, and the prime consideration that an essential commodity ought to be made available to the common man at a fair price must rank in priority over every other consideration. With the passage of the Consumer Protection Act 2019, which repeals the Consumer Act of 1986, there have been recent advancements in the subject of consumer laws in India. However, it's time to consider logically whether these regulations are indeed beneficial to the nation's economy. Now, let's talk about the cost-benefit analysis. The cost-benefit analysis, that is, the ratio of an activity's costs to its benefits, is the foundation upon which all decisions in economics are made. Another name for it is the cost-benefit trade-off, and it is one of the fundamental ideas of an economy. An economic activity should only be conducted if its benefits offset the costs. Beginning with the basic idea of market equilibrium, changes in the market's aggregate supply or demand will always result in adjustments to the equilibrium price and quantity. Taking a closer look at consumer laws, we can see that when regulations defending consumer interests become stricter or more customer-centric, consumers make more demands because they have more faith in sellers' honesty and integrity, which causes the demand curve to move the right increase in demand. There is a negative impact on the supply curve. The Consumer Protection Law of 2019 has made legislation more onerous for manufacturers and sellers, which has caused them to lower the number of items they supply. This has caused the supply curve to move to the left, or there has been a decrease in supply. The equilibrium price rises and the equilibrium quantity falls as a result of this shift, which is significantly more than the shift in the demand curve. The cost of things will gradually rise, which will cause inflation, and unemployment will continue to spiral out of control. A reduction in equilibrium quantity will cause the economy to slow down, which will encourage the unemployment rate to rise even higher. Strengthening consumer protection regulations leads to an increase in market competition among vendors. An innovative idea always emerges in competitive market. The cost of producing goods drops with the development of new technologies or production techniques, and sellers are willing to offer goods at a lower price to pass on the savings to customers and move the supply curve to the right, that is, increase in supply. However, this change is slight and only becomes apparent in long-term manufacturing. The information economy is a significant factor that also needs to be considered. Consumers are granted the most significant right by the Act, which is the right to information about the quality of goods on the market, the technology employed, and the government laws governing their manufacture and distribution. Understanding an individual's decision-making process, how he will divide his limited resources amongst various goods and services, and how this will affect the economy as a whole, are all part of the concept of economic opportunity. Because they are safer to use, consumers with limited resources would always try to direct their income towards these kinds of products and services. Consumers will only be able to direct their income towards safer products and services once the so-called right to be informed is fully implemented, especially in services where information is scarce for the general public. Only then will consumers have accurate knowledge about the goods available on the market and their effects. Regulating this is crucial in a nation where the service sector accounts for almost 60% of the GDP. Even if producing something possesses a risk to society, a producer will nevertheless make it if doing so will maximize his earnings. When he learns of the laws that forbid them and the consequences associated with them, he will cease to produce them. This will only be feasible if manufacturers and consumers are informed of the regulations controlling the manufacturing of hazardous material and consumer rights. Reaching the degree of widespread consumer and particularly producer education seems to be a significant economic challenge in light of the fake news landscape and the present Consumer Protection Act. The passage of the Consumer Protection Act of 2019 introduced the new idea of product liability, which holds the producer or maker liable for any damages caused by a defective product. According to Section 84 of the Act, even in cases where there is no proof of producer carelessness or fraud, the manufacturer is nonetheless responsible for any manufacturing or design flaws or deviations from manufacturing specifications. When we approach it from an economic perspective, it offers us a variety of ideas. Now, the first is, given that both our country and the exporting country may have different standards based on the rate of economic growth in their respective nations. How would one assess the usual standard and deviation of imported goods? Additionally, assessing an e-commerce giant's responsibility is a difficult assignment in this day and age of e-commerce. The second reason is that broadening the definition of product liability could lead to a reduction in the number of goods available on the market and deter manufacturers from developing new technologies. A completely alternative perspective might also exist, according to which manufacturers will now be more vulnerable to increased liability costs, which could deter them from making hazardous goods and raise worker productivity, but only in the long run of production. Such legislation should only be passed and put into effect by the government after considering its immediate and long-term effects on the economy. The government needs to determine the cost-benefit ratio beforehand to obtain economic gain in addition to political and social benefits. To improve economic results in the near term, the government must ensure that the producer receives incentives such as subsidies to compensate for the decline in supply caused by their loss of faith in government policies. This is only necessary in the short term since over time technological advancements will lead production costs to decline and the need for subsidies to disappear. Additionally, it is important to consider the issue of mass education. Information is like air in today's world, without which no one could exist. Eventually, the government's policies must guarantee that technical advancement occurs in order to offset the rise in manufacturing costs. In order to prevent such laws from having a negative effect on economic growth, the government must finally ensure that the cumulative effect of technological advancement and information economics is always greater than the effect of supply curve shifts caused by strict laws on producers and increased product liability on manufacturers. So after this, let's move on to the economic analysis of competition law. Economics has significantly impacted competition law. In the past, courts worked to defend competitors rather than rivals. Courts now shield smaller businesses from antitrust liability based solely on the economic threshold that considers antitrust market impacts. The per se rules have given way to the rule of reason analysis. Two new tendencies have arisen due to the shift in the understanding of competition law. The first trend is the growing importance of economic efficiency, and the second is the requirement to show market consequences that are anti-competitive. Economic behavior and the economy are fundamental to competition law. To make competition law more understandable in those terms, an economic evaluation of concepts like market definition and market power is required. Understanding markets is essential to understanding competition law. The primary goal of this area of law is to guarantee that suppliers are always in rivalry with one another and the buyers and consumers profit from this competition. Market identification and an evaluation of the effectiveness of competition are necessary for the application of competition legislation. Economics covers the functioning of markets. Understanding economics allows us to comprehend how markets work and determine whether companies' actions will lead to competition that will likely benefit the consumers. Economics is now a crucial tool for identifying market limits and gaining access to market power. Throughout the past 4 decades, developed market economies have seen a significant increase in the application of economics to the research and implementation of competition law and policy. Economic tools that have helped competition law enforcement in developed market economies focus investigations and help decision makers distinguish between central and secondary issues are inevitably less well understood in younger and developing market economies. Competition law itself has a history of 20 to 25 years at most, sometimes much less. It's likely that the most widespread understanding of what competition in economic theory means is that it's the antithesis of monopoly. This kind of thinking has regrettably led to a great deal of misunderstanding regarding the connection between companies' conduct and economic efficiency. Regardless of how sellers undercut prices, buyers bid prices, or new businesses enter lucrative industries, competition entered economics as a concept with practical application to modern business behavior. In a fundamental sense, the traditional distinction between monopolies and competition was appropriate from the start. The theory of monopolistic competition further supports this distinction by explaining that it is an imperfect form of competition where a number of producers sell goods that are distinct from one another due to factors like quality of branding, for example, etc., and are therefore not ideal substitutes. Now let's talk about the economic tools and measures applied in competition law. In mature market economies, the role of economics in the examination and application of competition law and policy has grown significantly. This assignment attempts to provide a non-technical introduction to three economic tools. The first one being vertical arithmetic, upward pricing pressure, and critical loss analysis. These tools are becoming common in competition law enforcement in general and in study of proposed mergers in particular. Now let's talk about the first of them, that is critical loss analysis. In the field of competition law, critical loss analysis is becoming more and more important. Calculating a critical loss determines the quantity of substitution needed to broaden a preliminary applicable market definition, which is the loss in sale or output required to render a specific price increase unprofitable. Critical loss analysis addresses several shortcomings in the existing market definition technique by disregarding the profitability of hypothetical price increase and placing an undue emphasis on product attributes and absolute price differences. It is a rather straightforward computation that closes a gap in the methodology of market definition determination and more accurately represents the market definition test. This examination is frequently known as the SSNIP test in the United States or the hypothetical monopolist test otherwise. Joseph Simpson and Barry Harris developed this test. Now the critical loss formula just takes into account the size of the proposed price rise and the profit margin or contribution of the group of companies trying to raise prices. To determine whether substitution effect larger or smaller than the critical loss seem reasonable and plausible, one can compare the critical loss with company, industry, and general market data. The information is crucial for determining the size of the output effects needed for market definition. The FTC versus Occidental Petroleum Corporation case established the notion of critical loss in US law. This strategy uses cost estimations. The profit maximization derivations on SSNIP tests are based on the difference between price or sometimes marginal revenue, and marginal cost. This lets us look at the incentives of real businesses or the made-up monopolists. However, in the normal course of business, business enterprises typically compute variable cost rather than marginal cost. A variable cost is one that varies according to the costs and output of production. When the overall cost of production varies, there is a marginal cost. Fixed costs do not impact the overall cost of the production because they remain constant. True marginal cost, which is the first derivative of total cost, includes a rental value of capital implicitly. As firm and/or industry production approaches capacity, this phrase may become particularly significant. Now let's talk about the upward pricing pressure. With the use of upward pricing pressure, one can calculate the likelihood that a merger will result in unilateral impacts or not. A merger between A and B could have unilateral effect since the combined company would internalize consumers who would have switched to B in reaction to a price hike. The degree to which rival items were near or far alternatives for one another was given more weight, a notion that was incorporated into the phrase. The next topic that we'll discuss is vertical agreements in competition law, that is vertical arithmetic. The economic tool is important to know about when there are vertical agreements. When two businesses with strong market positions and complementary offerings merge, it raises the question of how pricing and competition will be affected. This covers conglomerate mergers between the suppliers of goods that consumers assemble into a single system, as well as vertical mergers between businesses at various stages of the supply chain. We shall review here the double marginalization problem. Now, double marginalization is a vertical externality that happens when two enterprises at separate vertical levels of the same supply chain, each having market power, that is, not in a condition of perfect competition, mark up their prices. This twofold markup results in a loss of deadweight due to underproduction resulting from the end product being priced higher than the ideal monopoly price that would be established by a vertically integrated business. Monopolistic rivalry further amplifies this deadweight loss by exacerbating the loss of surplus. The free rider concept outlines the benefit of sticky and minimal expenses in vertical partnerships. Merchants of a particular good or service can increase their profits by investing more in creating sales-related services after implementing a higher markup, as they are unable to compete on price due to maintenance of minimum resale price. Enforcing the terms of an antitrust law is a different matter entirely from simply having one in place. It is undeniable that the Indian economy is experiencing a period of extreme inequality between the affluent and the poor. It is a terrible reality that there are significant differences between the classes of individuals at the bottom and the top of the economic ladder. On one end of the scale, we witness an almost obscene display of riches. On the other, there is a sense of desperation as one does not know where one will get their next meal. Of course, there are a lot of causes for this disparity, but with the introduction of regulation to stop anti-competitive activity, the focus has shifted from preventing monopolies and unfair trade practices to encouraging competition for the benefit of the general public. Both the executive and those tasked with carrying out and realizing the goals of the Competition Act 2002 are assigned in a manner that prioritizes the common good and guarantees the operation in order to fulfill the Constitution's mandate to ensure economic, social and political justice, as well as the ownership and control of the material resources of society. Thank you very much for your patient listening of today's lecture. I hope you learned something today. Thank you.